Showing on this episode of the program, a conversation on the implications of the Supreme Court judgment on the CBN Redesign Policy, the Lawan Judgement, and much more. We have the views of a senior advocate of Nigeria and King's Counsel, Professor Fidelis Odita. Also showing on the program, reactions of some senior lawyers on the President's directive to the CBN vis-a-vis the decision of the Supreme Court on the Naira Redesign Policy, plus a recap of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Sheyeli. The judiciary has come under serious scrutiny in recent times based on some decisions that have come out of the courts lately. One recent example is the Supreme Court judgment of Monday, February the 6th, where the President of the Senate, Senator Ahmed Lawan, was declared as the authentic candidate of the All Progressive Congress APC for the Yobe North senatorial ticket for the February 25th elections.
I think one has to start by saying that oftentimes judges are criticized a little unfairly, and because judges perform their functions in a public place, they're subject to public scrutiny. But the expectations of the public is not always coincident with the law. And so one must bear that in mind in criticizing judges, because it is not always the case that judgments must be given to reflect public expectation, unless that public is a well-informed public, well-knowledged in substantive and procedural law. Having said that, the Yobe case is somewhat tragic in many ways. First of all, because it does appear to legitimize the impunity which has undermined governance in Nigeria, and indeed the entire social and economic life. People do what they want, when they want, and how they want it. It's clear that Mr. Lawan wanted to be president of Nigeria, and that he did not participate in the Yobe North senatorial primaries. And what is perhaps more interesting is that the Yobe senatorial primaries were conducted in Yobe North, Yobe East, and Yobe South on the same 28th of May 2022. So all three senatorial primaries took place the same day. Lawan, having lost his election, his bid for presidency, organized what must be regarded as a kangaroo primary on the 9th of June and declared himself the winner. But it is not just that. It is the fact that there is such indiscipline among the political parties. Why on earth would a leading political party, which knows what the Electoral Act provides for, knows what the electoral guidelines are, knows what his own party constitution provides for, submit in the name of Lawan? That is totally lawless. So they shouldn't do that, and we mustn't blame just the court alone. These political parties have a huge responsibility to obey the law. But then the reason we criticize the court is because if they fail to obey the law, then the court should correct them, which is where the judgments in the Yobe North case come in. The two lower courts, the High Court and the Court of Appeal, held that Mr. Sheriff Machina was a legitimate candidate. At the Supreme Court did not even dignify us with the question whether that is a correct outcome in terms of merit. The Supreme Court took refuge in procedure, and I think it is very unfortunate. I have often said on this program and many others that Nigerian law is excessively procedural, but it is not always clear whether the refuge in procedure is as a matter of institutional competence, or is self-serving incompetence, or is deliberate. But it has certainly done a lot to disparage the law and to bring the law into disrepute.
This reliance on procedure, or what some will call technicality, where do you think that we're getting it wrong? Is it in the laws or in the attitude of the judges?
I think we're getting it wrong in the application of the law by the judges. The failure of the Nigerian courts to understand and apply the distinction between questions that are truly jurisdictional on one hand, with questions that are merely procedural or matters of admissibility. Is this claim admissible? Should I hear it? There is a clear daylight between those two, and it is the misunderstanding of those two that has encouraged the belief that Nigerian law is technical. It didn't used to be like that in the past. If I were in London, the judge is not going to follow a formula and say it has no jurisdiction. It will have to analyze the statute and say, what is the intention of the statute? Did the lawmaker intend that if somebody brings his proceedings by originating summons, I should not hear it? How can we accommodate such disputes of fact? Did they raise those disputes of fact before the lower tribunal, which had the power to call oral evidence? If they did not raise it, why are they raising it here? And there are so many Supreme Court decisions showing that where there is a procedural defect in a proceeding and the person takes steps, notwithstanding the existence and knowledge of the defect, that you waive it. That is an easier way to deal with it. But because they did not want to engage with the substance of the case, because if they engage with the substance, Lawan will go back, they left it that way and simply said, oh, you have brought your claim by originating summons, there is dispute, with all due respect to them. Anything, they have mischaracterized the facts before them. Those facts did not give rise to any substantial disputes. Those facts did not give rise to any material allegation of fraud or crime. The allegations of fraud there were conclusory. The way you would say, I am the candidate produced by the primary election held on the 28th of May. The one held on the 9th of May is not in accordance with the law. Therefore, the party has fraudulently submitted his name. It doesn't mean you are alleging any fraud. You're simply saying in colorful language that you are the candidate, and that's all that they said in their originating summons. There was nothing wrong with originating summons. Obviously, the Supreme Court has said, but that's a danger with the approach of the Supreme Court. I think there is a degree of arrogance in adjudication by saying, oh, well, we're the final court, we can do what we like. I just hope that that doesn't get into their head, because there's a danger that we're beginning to see more of that in the court decisions, and it portends grave danger for the country. They should also bear in mind that it is not simply the case that the Supreme Court has made a person who did not contest, Mr. Lawan, the candidate. It is the APC which submitted the name of Lawan. And that's why I started by saying the parties have a responsibility for the sustenance of democracy. You cannot have democracy or rule of law where a party and its chairman and secretary fail to observe the most basic provisions of the Electoral Act and their own party constitution. It is very unfortunate, and it shows that people have not taken their responsibilities seriously or at all, because I do not see how a serious party can submit the name of Lawan, and I do not see how a court which is properly seized of what the issues are should take refuge in procedural niceties instead of engaging with the question whether the party has acted lawfully in disregard of the Electoral Act.
The way that you've explained it makes it clear that there are options open to INEC, because a lot of people will think that because it's the Supreme Court, it ends there. But let's go on to the Osun State Governorship Election Petition Tribunal, which was another controversial one and with severe implications for the 2023 general elections. But it's good to know that the parties are now back in court. But do you think that INEC can conduct credible elections?
I think the Osun decision is very unfortunate. Of course, in any dispute, one person has to win or lose. But as lawyers, whether we're practicing or we're on the bench, we have a responsibility to ensure that we don't truncate our democracy. And that's why it's been said that those who make peaceful change impossible make violent change inevitable. I worry so much for the Osun decision because they are telling us, in effect, that there's nothing we can do to have credible election, and that whatever you do, the courts will upset it. But that's not the function of adjudication. The function of a judge is to dispense justice according to the law. We must ensure the survival of our democracy by ensuring that the votes cast by the people count and that the courts do not take refuge in irrelevancies and trivialities just to amuse themselves and confuse and derail our democracy. So there is nothing to commend the Osun, not because of the unfortunate use of Buga language. And I think that shows the flippancy of Justice Kume, because there are contexts in which you can have recourse to music. There are contexts in which you can have recourse to poetry in your judgment to emphasize a point. But the context in which he used Buga and lo 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 was in a mockery and condescending context, where he was saying, "Someone, you are not the person elected, and you are going to Buga. You can't be Buga." I think that is most unfortunate.
But with the way the judges are going, how do you think that it would impact on the elections? Do you think that people will have confidence in the system and the outcomes of the elections?
I have every confidence that the elections which will come on the 25th of February and the 11th of March will represent the views of Nigerians, and that everybody will know that Beavers is not on trial, that instead it is those judges who misunderstand, whether due to incompetence or deliberately, the provisions of the law, that are on trial. It is not the system. One person cannot be bigger than the system. And what the judges must understand is that the law exists as a means to create an orderly society. The judge cannot do as he or she pleases, because it is not in their gift. They are not emperors. They are people put there by law. So they have to respect and honor the law. They cannot act as if everything belongs to them.
Let's move on now to the new Naira Notes Redesign Policy of the Central Bank of Nigeria, which has also landed in courts. What do you make of that policy, the implementation, and the decision of the Supreme Court?
I think the Supreme Court's decision is a bit opportunistic, because, first of all, I would have thought, first of all, the true parties were not before the court. If you are challenging my action, surely you must bring me before the court. That's one. The CBN was not. There were no representative commercial banks, so that the court can have the benefit of the views of those who are likely to be affected by decision.
It was ex parte.
It was ex parte, but the application itself was ex parte, but the proceeding, it's not ex parte. I mean, there are parties to it. These people are not parties.
The parties are the attorneys general of 3 states.
Of 3 states and the federal.
Yes.
What is perhaps more interesting is the fact that these governors appear to be acting cynically. Why are they crying more than the bereaved? I don't see that the states pay anyone, whether salaries, pension, or indeed any material expenditure in cash. They do transfers. So why is it their business whether people are suffering? The reason they gave when I read the affidavit of Aisha Diko in support of the ex parte application is that the good people of Kaduna State were suffering. The children of Kaduna State were at home for almost a year during ASU's strike, and it didn't occur to them that they can take the federal government. And they've been kidnapping the good people of Kaduna. And of course, not the ones, those girls that were kidnapped from Borno. Those girls, some of whom have still not been recovered. That did not agitate them sufficiently to go to court under sanction. So one can only see their action for what it is, which is opportunism, cynical, self-serving action designed to allow politicians to have cash with which to purchase votes. That's all it is. The fact that people are suffering hardship could be due to the fact that the commercial banks are holding the new currency. It could be due to fraud on the part of commercial banks. It could be due to the fact that they are selling the new notes to politicians. It could be due to the fact that they are selling the new notes to POS merchants. It could be due to the fact of the wickedness of all of us as Nigerians who seek to exploit our fellow citizens at every opportunity that we have. It's nothing to do necessarily with the CBN policy.
Welcome back. Two senior advocates of Nigeria, Femi Falana and Dr. Paul Alanaba, have strongly criticized the president's insistence that the old 500 and 1,000 naira denominations are no longer legal tender. They've also faulted the decision by the president to reintroduce the old 200 naira notes into circulation, describing the decision as an affront to the Supreme Court.
In an official address in 2018, President Buhari, told Nigerian lawyers in Abuja that my government will not obey court orders because of national security. His Attorney General, Mr. Abubakar Malami, SN, has repeatedly insisted that this government will not obey all court orders. Again, on account of national security. So, for that reason, I wasn't surprised. In fact, I would have been surprised if the government had complied with the court orders. Because despite the fact that President Buhari continues to say that he is a converted Democrat, he doesn't believe in the rule of law with profound respect. I have a record of over 100 court orders that have been disobeyed. I also have a record of about 40, Nigerian courts, of about 40 orders of the ECOWAS court that are ignored by this regime. But for me, it is unfortunate because what is the essence of that speech? Number one, we're going to treat the Supreme Court with contempt. Two, we're not going to change our position other than to say, 200 naira notes should be added to the new notes. Where are the new notes? That is the issue. By now, we had asked the central bank, please tell Nigerians, how did you disburse money to the bank? How much did you give to each of the banks? And since the bank has a return regularly of money given out by the banks, okay, who has collected what? Because nobody can collect money in the bank without signing for it. So why are they deceiving Nigerians into believing that, a few people are saboteurs? So who are these saboteurs?
The president is the father of the nation, so it was good to hear him speak. However, when you look at the 24-paragraph speech of the president, you will appreciate him. He's shown concern, he feels the burden of the nation. He established the fact that he understands that Nigerians are in pains and suffering. But beyond that, he also told us that he is aware that court orders or decisions have been made. The area I am concerned about the president's speech is that he now goes on to say, it is only 200 naira that will be legal tender. 500 and 1,000 are not. And that flies in the face of standing or order ruling of the Supreme Court, suspending that policy. So he now raises a series of issues. Is the president directly annulling that decision of the Supreme Court? Is it an appeal situation where that decision has gone on appeal? to the executive or what? That's the area I don't agree with the speech. And I think that the president will do something about it, because it throws off so much confusion, throws off so much uncertainty. And then what you see, the state governors go to town to say in their states, you either accept the money or we sanction you. Now, what will the citizen do? Is the citizen expected to obey the Supreme Court and continue to use the 1,500 as legal tenders? Or is the citizen going to say, no, they are no longer legal tender, even when the Supreme Court have said they are, until the Supreme Court finally disposes of it? As a legal practitioner, I will comply with the decision, the orders of the Supreme Court, whether I like them or not. And that's what Section 287 of the Constitution says, that the decisions of the Supreme Court must be obeyed by every authority and person. Authority includes the office of the presidency.
And just before we go, let's quickly do a recap of some of the other top stories from the courtrooms.
We begin with the report that the Supreme Court has joined Katsina, Lagos, Cross Rivers, Ogun, Ondo, Ekiti and Sokoto states as co-plaintiffs in the suit challenging the Naira redesign policy of the federal government. Similarly, the Apex Court also joined Edo and Bayelsa states in support of the federal government on implementation of the policy. The 6 states in their motions for joinder pitched their tents with Kaduna, Zamfara and Kogi states who had initially filed the suit. The 7-man panel led by Justice John Okoro also says its February 8th order barring the federal government from enforcing the February the 10th deadline for the use of the old notes of the 3 highest denominations of the Naira still stands. This clarification became necessary after counsel to the initial 3 states, Mr. Abdul Hakim Mustafa, told the court that the federal government and its agencies have failed to comply with the February 8th order. The court subsequently adjourned the case to February the 22nd for hearing of the consolidated case and directed the plaintiffs to amend their originating summons to reflect the names of the states who just joined the suit. Staying at the Supreme Court, the appeal filed by Professor Tehemba Shija against the All Progressives Congress primary that produced Reverend Father Hyacinth Alia as the Benue State governorship candidate of the party for the 2023 general elections has been dismissed by the court. Justice John Okoro, who led a 5-man panel of justices, dismissed the appeal following its withdrawal by Professor Shija. The court also heard that the appeal was statute barred. The Apex Court also entertained an appeal filed by a member of the People's Democratic Party in Benue State, Mrs. Aida Oguche, who is contesting for a seat in the House of Representatives. However, her opponent, Mr. Francis Agbo, wants the court to dismiss the appeal, alleging that Mrs. Oguche violated the law by refusing to resign from her position at the Federal Inland Revenue Service at the time she stood for the election. After taking arguments from the parties, the Apex Court then fixed February the 22nd for judgment. In Lagos, a federal high court sitting in Ikoyi has fixed March the 28th for the hearing of a final forfeiture application of the sum of $5.8 million and 2.42 billion naira said to belong to the former First Lady Dame Patience Jonathan. Justice Tijani Ringim fixed the date after listening to the arguments of counsel to the Economic and Financial Crimes Commission, Mr. Rotimi Oyedepo, a senior advocate of Nigeria. Defending counsels Michael Zekome San and Sami Somiari San had appealed to the court that the case be adjourned pending the outcome of their appeal. But in a swift reaction, Oyedepo opposed the application. Justice Ringim upheld Oyedepo's submissions and directed that the motion for final forfeiture will be taken and determined first as canvassed by the EFCC counsel. At the Lagos State High Court sitting at the TBS, the state government has closed its case in the murder trial of the Assistant Superintendent of Police, Drambi Vandi, who allegedly shot Lagos-based lawyer Bolanle Rahim on Christmas Day. The prosecution closed its case after calling the 11th witness, a pathologist, Dr. Oluwaseun Williams. In his testimony, he said the examination conducted on the late Bolanle Rahim established 3 factors as the cause of her death, which are hemorrhagic shock, destruction of the chest visceral, and musculoskeletal tissue. The pathologist also mentioned in his testimony that the post-mortem report confirmed that the late Rahim was pregnant, adding that the gunshot was at close range. The defense counsel Adetukubo Odutola has indicated that he will file a no-case submission seeking to quash the charge against the defendant. Following his submission, Justice Harrison ordered both counsels to file their motions and written addresses and adjourn to February the 28th for the adoption of the court processes.
That's the program today. If you missed any part of it, you can find it on past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shayeli. Thank you for watching and see you next week.